Go ahead, Mr. Dillard.
Thank you, Your Honor. Mr. Dillard, you said the morning after Mr. Jensen made these disclosures to you, then got moved back to an institution.
That's correct.
Which prison did you get sent to?
Dodge Correctional.
Now, did you ever write out your recollections of the things that Mark Jensen had told you?
To my lawyer, yes.
And was your purpose in that letter to recount every single thing that Mark Jensen had told you, or just enough to give her an idea what had happened?
Just enough to give an idea what had happened.
And what was your purpose in writing the letter to your attorney?
Just to get the communication started with you.
Your Honor, request that this document be marked as an exhibit. This is, you've seen this, right? To put it right here. So, thank you. How much time elapsed? Well, strike that. Where were you when you wrote this letter to your lawyer?
DCI.
You were back at the prison system?
Yes.
And what day was it, or how many days was it that you were back there before you wrote this letter?
I would say it was within a week.
So at the time you wrote the letter, matters are still fresh in your mind?
Yes.
Now, I want you to go back to the point in the conversation between yourself and Mr. Jensen where he was first talking to you about what he'd actually said to Ed Klug.
About Ed Klug or to Ed Klug? Oh.
What he'd said, when he was first telling you what he'd actually said to Ed Klug. Did he ever tell you what he'd actually said to Ed Klug?
He never told me exactly what he said to Ed Klug.
Did he ever tell you that did he confirm with you that he had actually spoken with Ed Klug?
Yes, he did.
Tell us what he told you about when he spoke with Ed Klug.
Just he was going, I mean, there wasn't a whole lot he told me, he said. I mean, I read the transcripts and got everything from that of what their conversations were. As far as Ed Klug goes, he just, at the part when he said when the discussion about killing her came up, that's when he said he messed up and told Klug that stuff.
So tell me everything you can remember about what he said to you about how he messed up.
Oh, he just said that he messed up because he tried poisoning Julie before he left for his convention, and that he said he was talking to Klug about how to kill your wife, things like that.
Did he ever tell you why he was talking to Ed Klug about how to kill your wife?
Just from the most part that they were drunk and they were talking and just wife bashing.
Did he ever tell you anything about trying to poison his wife at the time or shortly before the time he'd spoken with Ed Klug?
Objection, asked and answered. You just said this.
Sustained.
Well, I'm going to ask you, I'm going to show you this letter that you wrote. I'm going to show you this letter and ask you if you can identify it. Just read it to yourself. Don't read it out loud.
Objection.
Sustained.
Sustained, you said? I didn't hear what you said. Okay. Well, do you recall writing to, telling your lawyer, or in this letter, do you recall telling her?
Objection, hearsay.
Sustained.
Well, if I'm not allowed to let him look at it,
Is his memory exhausted on the subject?
is there anything else you can remember about the conversation that occurred between you and Mark Jensen regarding the circumstances of his conversation about Ed Klug and his conversation with Ed Klug?
You know, I don't know. I mean, I don't remember everything that I said because it's so long ago.
At the time that you wrote this letter to your attorney, were matters fresher in your mind at that time?
Yes.
If I were to show you the letter, might that refresh your recollection?
Yes.
Now you're on request that I be permitted to show the witness the letter and have him read it to himself.
That portion,
I still object. I don't think it's proper refreshment.
I don't understand why you would think that, but, and the objection's overruled.
Just start reading to yourself right there.
I remember
No,
this just from the first.
just read it, and just read it, all of it, and after you're done reading it, then let me know.
Okay.
Now, does that refresh your recollection any further as to what Mark Jensen told you about about the circumstances surrounding his conversation with Ed Klug?
Yes.
Okay. Tell us what else he said to you about his conversations with Ed Klug.
He just said that he had screwed up in telling me that, and that he, well, both basically said that he said that, I'm just trying to remember what I wrote there. I know what I wrote, but I'm just getting confused in my mind.
I don't want you to remember, if what you wrote here refreshes your recollection as to what he told you about Ed Klug, then I want you to tell the jury. If it doesn't refresh your recollection, then let me know that.
Well, it refreshes my recollection. It's just that what I had written there was in regards to what we had already discussed earlier about how he screwed up when he said he was talking about how to kill his wife and those things. I mean,
Did he tell you, did he indicate to you why he felt that he had made these statements to Ed Klug?
can I read that again? I'm sorry.
I object. He read it. His memory obviously wasn't refreshed. It's improper to have him regurgitate what's in the statement. It's whether he...
But he can't recite what he reads in the statement. And in fact, that was one of his prior answers. He was testifying as to what he wrote, which is hearsay. However,
I think I've laid the foundation for a recorded recollection.
If it refreshes his recollection, he may read what he wrote.
Well, Your Honor, I think also as a recorded recollection, he can read what he wrote. If it doesn't refresh his recollection, then it's a recorded recollection.
All right.
And I believe I've laid the foundation for that.
All right.
And it hasn't apparently refreshed his recollection, so I request that he now be permitted to read to the jury what is contained in this last paragraph.
Objection. It is hearsay, and it remains hearsay. I don't. It's not says.
Hold on a second. Let me just look at the rules.
Now let's play your pocket.
I'd ask that the document be removed from the witness.
Yeah, just turn it over for a second.
Yes.
Oh, that won't do it because it's got writing on both sides, so I'll just take it. Thank you.
It's not a...
The objections are ruled.
So I need to read that from here. So directing your attention to the paragraph that begins with the words "he said."
Yes.
Could you please read what you've written there out loud to the jury?
He said he wishes he hadn't opened his stupid mouth around his coworkers about him wanting to kill his wife. That's what's fucking him now. This was at that conference 1 month before. He said he got drunk and stupid because he was feeling guilty because he tried to poison her before he left for the trip. He said when he got home from the trip, she had thrown up all over the carpet in the house and was lucky she didn't die, and then chuckled. Said he would...
I object because he's testified to most of this before. It's improper. It's not...
This part strikes me that this has already been testified to.
There was never any discussion about or any statement about the defendant chuckling as he's describing his wife vomiting all over the floor.
Go ahead.
Okay, that was my misunderstanding of what you were asking because I thought...
No,
okay.
you didn't misunderstand it. Just pick up where you left off and keep reading, please.
Okay, she said he wouldn't have really been... He said he would have really been screwed then. He said he would ask her to pick up medicine for him from the doctors as well as...
No, we won't go there yet because that's
Okay.
that's beyond what I was asking about, but thank you.
Oh,
Okay? Now, did Well, did Mr. Jensen ever make any statement to you about asking his wife to pick up medication for him?
Yes.
And what did he tell you about that?
He said that he would actually have her pick up the Literal for him because it was his medication for his esophagus problem. We had talked about...
Did he indicate to you why he would have his wife pick up the medication for him?
I don't recall exactly what was said, but I think it was a reference to just, her picking it up. And we discussed that in how, when we were playing devil's advocate, how to prove it. And that's when it came up about the debit card receipts, or did she sign for the medication and things like that.
Okay. When he described to you leaving his wife on the day of December 3rd and running some errands, did he ever disclose to you how he expected to find her when he came back?
No, he didn't disclose to me. He didn't say she should be dead.
Did he describe to you any expectations he had concerning how he'd find her when he got back?
He never disclosed it, but I'm sure he's feeling she'd be dead by then.
Well, when he... I don't need further question on that. Now, you indicated that you still have a case pending in Racine, is that correct?
That is correct.
Have you been charged in that offense?
Yes, I have.
And what were you charged with?
Theft by contractor and home improvement fraud.
And do you know what they're alleging that you did?
Yes.
What are they alleging that you did?
That I took a deposit and didn't start or finish the job done, the work to be done.
And did you take a deposit?
Yes, I did.
And at the time you took the
Oh,
deposit?
excuse me. I'm sorry. I didn't take a deposit. I'm confused at what you're asking me. That's what they're accusing me of, taking a deposit and not doing the work done.
Did you collect any money from this person?
Yes, I did.
And was that to be a deposit for some work that you were to do?
No, it was not.
What was the money that you collected from this person?
It was money I borrowed.
And how much money was it?
$6,200.
And when did you borrow that money from her?
November 2nd.
And when you borrowed the money from her, did you tell her when you would pay her back by?
Yes, I did.
And when did you say you'd pay it back by?
December 17th, I believe.
And what were you going to do with this money?
Spend it.
On what?
Well, I actually gambled with it.
Do you have a gambling problem?
Yeah.
You did?
Yes, I did.
Do you consider yourself a gambling addict or not?
Yes.
So where'd you gamble this money away?
Vegas.
So you got this woman to to lend you $6,200.
Mm-hmm.
And did you tell her that when you were borrowing the money from her that you were going to use it to go gamble in Las Vegas?
I didn't give her a reason.
You just asked her if she'd lend you the money.
Yes, I did.
And what sort of things did you say to her to get her to lend you the money?
I just asked her if she'd borrow it to me. I said I needed money and asked her if I could borrow it.
Did you ever tell her how you were going to pay it back?
No.
Did you have any idea how you were going to pay it back?
I had plans, yes.
But when she asked for the money to be repaid, you didn't have the money to pay her.
She asked me on November 3rd and actually went to my family's house and demanded that they paid on November 3rd.
And they didn't have the money to pay her, did they?
Why would they? It was my debt.
And you didn't have the money to pay her on November 3rd either, did you?
I was expecting it by December 17th about our agreement.
And how are you planning on getting the money by December 17th?
My wife's 401 or winning.
So you were going to ask your wife to cash in her portion of her 401 to pay back the money that you'd borrowed
Yes.
and then gambled away?
Yes.
By the way, is there a condition of your probation that you're not to gamble?
Now there is.
Did you ever repay her the $6,200 that you owe her?
No, I did not. We're in court proceedings for that now.
Did Mark Jensen ever show you any other document aside from Ed Klug's, the transcript of Ed Klug's testimony?
He never showed me any documents.
Oh, you never saw Ed Klug's
I
transcript?
mean, besides Ed Klug's statement, you said other than, he never showed me any,
That means you can answer the question, sir.
oh, okay, he never showed me any other documents besides the Klug statement.
Did you ever see any documents of his besides the documents that he showed you?
No,
Did you ever go snooping in his cell for
Never.
his documents?
never,
Did you ever see any other inmate go snooping in his cell for his documents?
never,
Did you ever see any other inmate go snooping in anybody else's cell for anybody else's documents while you
No.
were there? Oh, I apologize, Your Honor. Did you ever read any newspaper articles about the Jensen homicide prosecution?
yes,
Did you read about did you read those articles before or after you wrote this letter to your attorney?
well, I wrote some of them before I even went to Kenosha County.
You read some of them before?
Yeah, I read some of them before I even went to Kenosha County Jail and met Jensen.
So you knew who Mark Jensen was when you got to Kenosha?
Yes,
But did you know him by sight?
no,
Did Mr. Jensen ever explain to you why he went to the doctor's office to get Ambien for his wife?
He said she was very depressed. That's in the beginning what he was telling me. We never recapped on that conversation.
Well, was that about the Paxil or about the Ambien?
Oh, about the Ambien, sorry, I made the mistake about the Paxil. The Ambien, he
Yes.
said that she was, because she wouldn't sleep and she was acting all giddy and stuff, and that he wanted her to sleep through everything.
He wanted to sleep through everything?
Yeah.
Did he explain to you what he meant by everything?
No, he didn't. He just said he wanted her to sleep because if she was complaining, it might make it worse.
Did he said it might make it worse?
Sustained.
Well, I'm trying to understand what it was he told you about the Ambien. So did he say anything else about the Ambien?
Nothing else about the Ambien. He just said he went to the doctor the day after the Paxil incident because he needed something to calm her down because she was worried about the Paxil, the side effects of the Paxil. Because of what they researched online.
Thank you, Mr. Dillard. I don't have any further questions of you.
Mr. Welby? Didn't I give that to you already? Did I already give you that? It's Judge Barry's case? No. It's a 980, and they were the sentencing judges, and then there was a 985, and there was a substitution on Judge Barry, they're both mine. Are they identical?
What's that, Judge?
I'm sorry, yeah.
Oh, no problem. Mr. Dillard, you were picked up on May 31st, 2007 by the police, right?
Correct.
You testified that the reason you were being revoked is because you were doing a construction job you were not supposed to be doing, and you had a cell phone that you weren't supposed to possess, right?
As well as many other violations, yes.
You didn't tell us about all those other violations on direct examination, did you?
Objection, Your Honor. Counsel's mischaracterizing the witness's testimony, and he's arguing with the witness.
So, excuse me, can you repeat the question?
On direct examination, you were asked, sir, what were you revoked for, and those were the two things you told us, right?
And I believe I said that with other violations.
On May 31st, 2007, you were pulled over in a vehicle, right?
Correct?
You had a suspended registration, right?
Yes.
Police pulled you over and you said your name was Michael Kaiser, right?
That's correct.
And then you found out that the vehicle registration was suspended because of parking tickets, right?
Correct. Yes.
And you blamed that on your brother, Aaron Dillard, right?
Well, I blamed it on myself if I said it was Aaron Dillard.
But you were saying you were Michael Kaiser, weren't you?
Yes.
That's what you were saying, right?
Yes.
So you weren't blaming it on the person who was in the car stopped by police, were you?
Correct.
And then the police figured out that it was you, right?
Yes.
And then what did you do?
I went to jail.
You started crying, right?
I don't recall that.
You don't recall crying and telling the police that you didn't want to go back to prison?
Well, I told them that I didn't want to go back. Why
And you were crying, right?
I don't recall that. No, if they say I was, please, then I was.
You don't remember crying in your car on May 31st, 2007 because you had to go back to prison?
I was crying in my car? No, I was not.
Well, where were you crying?
I don't recall crying, but I wasn't in my car crying.
Can you tell me where you were doing your crying,
No,
mister?
I just said I couldn't recall. I'm sorry.
And that's because one of your violations was that you had absconded from probation back in October, right?
Correct.
You hadn't reported to your agent once since October 9th, 2006, correct?
Correct.
Thank you. Did you use back then?
And Mr. Dillard, in June 2007, there were 17 violations that they charged you with during your probation, right?
Correct.
And there were others that they determined you had committed that they didn't even bother to charge. Fair to say?
I wouldn't be able to say.
You operated a computer, right?
I was violated for that, yes.
You violated by possessing a computer, right?
Yes.
You violated by obtaining self-employed side jobs for Lori Brown and Cassandra Ivy without permission, right?
Correct.
You accepted cash and kept money provided for contractual home improvement work from Lori Brown and Cassandra Ivy, right? Right?
I said correct.
And violation number 6, you stole money from Lori Brown and Cassandra Ivy by failing to complete contractual home improvement work, correct?
Not correct.
So Lori Brown is lying when she says that you contracted for work and you didn't complete it?
Objection, Your Honor. Calls for one witness to comment on the credibility of another person.
Well,
Let me just do it a different
well,
way.
I want to be clear about this. Is this a charge where he's charged with one violation for entering into a contract and a separate violation for entering into the same contract? One for just entering into the contract at all and the second one for doing so in an effort to steal the money?
He's He has a violation for obtaining self-employed side jobs. He has a violation for accepting cash and keeping the money for contractual home improvement. And he has a violation for stealing the money from Lori
So
Brown.
is it 3 charges arising out of one transaction?
Well, I'll be asking him about it, I guess.
Well, I
The
just
answer
wanted,
is yes, Your Honor, that's what it is.
well, I don't know. The witness has to testify, but I think the problem with reading off the charges is that you're reading what someone else alleges as opposed to his individual conduct.
I don't know what let me just go. You stole money from these people, right?
No.
Now, Lori Brown was a lawyer, right?
I believe she was an office manager, but she was a lawyer in the past, I believe.
She had a law degree, right?
Possibly, I'm not sure.
You met her on the internet?
Yes, I did.
You told her your name was Aaron Galvin, right?
That is incorrect. She had wrote Aaron Galvin on a contract.
She wrote out Aaron Galvin on your contract? That's because she thought your name was Aaron Galvin, fair to say.
Okay.
You told her that you had a multi-million-dollar roofing company?
No.
You told her that you were negotiating the purchase of a large asphalt crushing machine?
That's incorrect.
You had a conversation in front of her about purchasing the large asphalt crushing machine?
Not correct.
You told her you were pursuing large state contracts for asphalt, correct?
Not correct.
She gave you money, correct?
Yes, she gave me money.
She gave you money to do a roof at her house, right? You didn't complete that work?
That is false.
You didn't pay Badger Supply for the roofing materials?
I paid Badger Supply for the roofing materials.
Every material? There's not a lien on her house?
Nope.
Did you pay the temporary employees?
No.
And she owes that money?
I'm not aware of that.
OSHA had to come out to the site because of your shoddy work?
I don't believe that's the reason why they came. Actually, we passed all OSHA inspections. It wasn't about shoddy work. OSHA is a safety inspector, not shoddy workmanship expert.
You told her that your wife and son were carjacked and killed in Lithuania, right?
Never had a conversation like that in my life.
You told her that while you were in prison in Lithuania for avenging the death of your son and your wife, that they were chanting "Free the American" outside the prison because they loved you so much.
That's incorrect.
So if Lori Brown says any of those things, she is lying.
Yes.
And Cassandra Ivy, you've been charged in that case, right?
Correct.
You've been charged with stealing her $6,200.
Yes.
You lied to her by saying you were bonded.
I've never said I was bonded.
She had to pay $2,600 to someone else to fix damage you caused.
I'm not aware of that.
And you said that your claim is you only lent her the money. Is that right?
I never said I lent her anything. I'm sorry.
I'm sorry, you only borrowed the money.
Correct.
And you said now it's being worked out in court proceedings.
For the theft by contractor, I was charged for that because she claims that I contracted to do some kitchen work.
Well,
and
what court proceeding do you need to give this woman her money back?
I'm assuming it's going to be a civil litigation if
Why?
I owe her any money.
Why would she have to litigate you paying her back her $6,200?
I have no problem paying her back. It's just that she went to my parents' house. We had a contracted with a payment due date of December 17th. On November 3rd, she went to my family's house and demanded the money. So I believe she violated the contract by demanding payment early.
So you think because she went to your parents' house looking for the money, you don't owe her $6,200, Mr. Dillard?
I believe I do owe her the money.
You think that was a violation of her responsibilities to you by asking for her money back from your family when you didn't pay it?
I wasn't even due to pay that payment back until December 17th. Why should I pay it back before the due date just because she demanded it?
Your claim is that you had no contract with this woman at all to do her, or let me not say contract. You didn't agree to do any work at her home?
I agreed to do her concrete.
And you didn't complete that work, right?
I believe I completed it.
You've been charged in Racine County for theft by contractor in that case, right?
Correct.
You're facing 6 years on that charge, right?
Correct.
And you're charged with home improvement fraud, right?
Correct.
You're looking at a year for that, correct?
Correct.
And the prosecutors have said that they're going to recommend no time on that charge, right?
Correct. If I were to take it to trial or take a plea.
And they're also you were charged with obstructing for your identification of yourself as Michael Kaiser in this other case, right?
Correct.
And you're facing 9 months for that?
Correct.
And they're also going to recommend no time in that case?
That's wrong. There was no recommendation made on that case.
Well, in the Racine case, you've had proceedings postponed until after this trial so you can get a deal, right?
That's not correct. I think that they were just waiting to see the outcome, or just to let me finish this first.
That's right, you're waiting to get your deal, correct?
No, that's not correct. I haven't even decided if I'm going to take it to trial yet.
One of your requirements on probation is that you give a statement about alleged misconduct, correct?
Correct.
You refused to give a statement about Cassandra Ivy?
I was violated for that too, yes.
Right, that was yet another one of your violations? Another thing that was reported in the last year while you were absconded is that you cheated a Dennis Ritt out of some money, correct?
Correct.
And you told him that you had a Russian cell phone contract, correct?
Actually, I told him I had a telecommunications company in Lithuania.
You don't, do you?
I did, and it still exists. It's just under new ownership.
You told him that you own the distribution rights for cell phones in Russia and you go there approximately every 2 weeks.
It's not correct.
So Mr. Ritt also is lying.
If that's what he said, then yes, he is.
You convinced him to lend you some money?
In a poker game, yes.
You convinced him to lend you some money?
Yes,
You didn't pay him back?
correct.
When you were arrested, you had a Quest card belonging to Celia Rubenstein?
Correct.
It wasn't your Quest card?
You just said it was Cecilia Rubenstein's crest card.
That's right. It wasn't your Quest card?
No, it was not my
You
question.
weren't supposed to have that as a condition of your probation?
No, I didn't know that at the time. I mean, I wasn't supposed to have possession of credit cards or debit cards.
You didn't know that?
As a Quest card, no, I didn't think it. I did my grandmother's grocery shopping. My wife's grandmother, so
Oh, you also had her Visa card,
yes,
so that was a violation, right?
that was a violation.
And you also wrote check out to a closed bank account, correct?
That was to Dennis Ritt.
I didn't hear the answer.
Yes,
That was to Dennis Ritt?
correct,
You knew it wasn't good?
correct.
And one thing you were asked about during your interview with the prosecutors here, all your crimes, you say are victimless crimes, is that right?
Well, there's a victim. I mean, somebody paid the money out to me.
You were present at your sentencing in the Kenosha case, the 0-0 case?
Correct.
And did you agree with Ms. Gabrielle's statement there that your crimes have always been crimes of property forgery and misappropriation, never crimes of harm against a person, physical harm or emotional harm?
If that's the way the law reads it, as a property crime.
How is this witness supposed to know that?
He's being asked to
You're
comment.
being
on
asked
somebody
to
else's-
comment on a statement made by Attorney Gabrielle.
Would you agree? Well, you were resentenced in, I guess is in 00 CF 1181, right?
Correct,
For violating your probation, right?
correct.
And the prosecutor came in and asked that you not be given any time, right?
They made a recommendation of having my extended supervision reinstated.
They asked that you not be given any additional custody time, right?
I think they made a recommendation of 155 days in prison.
That would be time you had already served,
Correct.
right?
Yes,
So they asked for no additional time for you, right?
correct,
Despite your extensive record, right?
correct,
Despite the pending allegations against you, correct?
correct.
And to justify that, they told the judge that your crimes did not involve emotional harm to anyone.
I don't know what they did to justify it.
Your Honor, I object again to this
Again,
witness.
I have to say, you're asking him
He
It
got,
doesn't affect the credibility of this witness, what someone else said. Whether he got some kind of a very beneficial deal or not.
but as part of his bargain, this is the extent that they went to and that we're entitled to present.
If that was agreed to, if he knew that that was going to be the representation that was going to be made, yes.
Well, I think it's also not just because I'm not bound by just what people say is the deal. I can also go into how far people go in trying to accomplish it.
Your Honor, may counsel approach?
No.
Well, Your Honor, it seems that counsel is suggesting that somehow Ms. Gabrielle did something inappropriate in a courtroom regarding Mr. Dillard's record. It's inappropriate for a prosecutor to misstate.
And I tell you what, I don't want to get into any further discussion on it. I am going to sustain the objection because he's not, you're being allowed to examine him about his truthfulness or lack thereof, and under the rule that you're proceeding, and to ask him to comment on the statements of others is not appropriate.
Judge, and just so it's clear, I'm also proceeding under 90609 because the whole thing was opened up.
Well, it's a close question. Go ahead. You may have the answer.
Your Honor, may counsel approach? I really, I object to this line of questioning when this witness is being asked to comment on what it is that Ms. Gabrielle said in a courtroom.
I know that. And the objection's overruled.
Ms. Gabriel told the court that she thought it was appropriate that you get no additional time in prison because you had never committed crimes of emotional harm. True? You recall that?
I don't recall her using those words. I don't recall it.
Do you agree that you haven't committed crimes that have caused emotional harm to anyone?
Sure.
Sure that you have committed crimes of emotional harm or you have not?
Well, I don't know if it caused them emotional harm. I mean, my crimes are generated at businesses. I bounce checks at like Mike's Foods. So I bounced them to the business. I don't know who's behind it, so I never met the people and I've never heard anything from them.
Okay, so your belief is you haven't caused emotional harm?
Correct.
During your recorded statement with the prosecutors, you characterized yourself as a woman victimizer. I have that right?
Yes.
And you have some bitterness against women that cause you to want to victimize them.
Did you say I have or I had?
You have.
No, I don't have anymore.
On what date did your bitterness towards women that caused you to want to victimize them end?
Yeah, I can't recall an exact date.
But in August 2006, for example, you were working to meet Lori Brown over the internet, right?
Correct.
You're sending her emails, right?
Correct.
To set up a meeting, correct?
Correct.
And then you obtained money from her, right?
I obtained a contract to do her roof and got paid for doing her roof.
And that work caused her additional bills to pay for the temporary workers, right?
No, I'm not aware of that.
You haven't paid the temporary workers.
That's correct.
And you understand that in construction, there can be a lien then on the person's
I understand. To my belief, a lien can be filed on the home if the homeowner knowingly knows anything that is being not paid or worked out. I'm not sure exactly how the law works, but I'm familiar with it a little bit. So I had no idea that she would be held responsible because she didn't even know I was using temporary employees.
So who are the women that you have victimized because of your bitterness?
Oh, let's see. Well, I could say Deborah Spears. That's pretty much it, I believe.
That's it? She's the only one?
That I victimized like that, yes.
Well, during your statement with prosecutors, you said there were 2 women.
Oh,
right?
I'm sorry if I don't remember the other one. I don't remember it.
Well, what about Deborah Spears? You were charged for stealing her debit card numbers to pay for a cell phone bill, right?
That is correct.
You were convicted of that, right?
Of misuse of a credit card.
Because she had allowed you to use her credit card on one occasion, correct?
That is correct, and I paid her for that.
Well, then you used it without her permission on another occasion and did not pay her back, right?
No money was taken from her.
Answer the question which was asked.
Can you repeat the question so I can hear it explicitly?
Could I have that read back, please?
Question, well, then you used it without her permission on another occasion and did not pay her back, right?
That is not correct. There was no money to be paid back.
Well, there was an unauthorized $500 withdrawal from her checking account, right?
That is correct.
Because you used her debit card numbers to pay your cell phone bill, right?
That is correct.
And then you lied to Detective, do you know how to say that? Oss? Is that who interviewed you?
I believe it would be Aussie.
Detective Ossie interviewed you, and you denied borrowing any money from Miss Spears, right?
That is correct.
And that wasn't true, was it?
No, I never borrowed any money from Miss Spears.
But when you used her debit card to pay for your cell phone, that wasn't borrowing?
I stole. That's what you had said.
Well, the first time you told me you borrowed, right?
Oh, the first time I didn't, yeah, I guess you could say I borrowed it because I gave her the cash in hand and she punched her credit card numbers into my phone at the same exact time.
Okay, so you acknowledge that you stole it?
For the second transaction, that's what you're saying is I stole the $500 by using her credit card without her permission. Is that?
Yes.
Okay, that's what is implied, yes, that I stole the second time.
Yeah. And you did, right?
And yes, I did. I'll say yes, I used her credit card to pay my cell phone bill.
Without her permission?
Correct.
That's called stealing, right?
I just said that.
Well, and you told Detective Ossie that the cell phone bill payment was an accident.
It was, but I pled guilty to it. It was. I mean, the numbers were programmed into the phone when I hit 111 to pay the bill using my wife's credit card. It overwrote her credit card at the time. So it was unknowingly I used her phone. I used her credit card because the cell phone company programmed her credit card over my wife's credit card number.
So you're telling us that that your cell phone had her debit card number in your phone?
No, the service had it programmed. The actual phone company, when you call in, use #666 to pay your bill, you enter your credit card number in there. The service stores the credit card as a payment, and it overwrote my wife. So when you program, like if you were to pay your bill today with one, you could just press 111 and pay your bill every month without entering a credit card number.
And what you did when you were in jail is you called your wife, Nadia, right?
That's correct.
And you told her to just say it was her that did it, right?
Yes.
Because you knew it was stealing the whole time and that it wasn't a mistake, right?
No, that's not correct.
And you also had Nadia call Deborah Spears, right?
Objection, Your Honor, to the conjunction. The witness denied the previous question and counsel's using the conjunctive.
You also had Nadia call Deborah Spears.
Yes.
I object to the also, because again, it's a conjunctive form. The witness denied the last question. He said no in response to the last question.
Rephrase the question.
In addition to punching in her number and stealing her money, you also had your wife call Deborah Spears from the when you were in the jail, right?
Yes.
The reason you had her call was to try to put pressure on Deborah Spears to drop the charges, right?
That's incorrect. I don't think it was pressure.
You told Deborah Spears that either she could drop the charges and let you out and maybe she'd see the money, or she could continue with the charges and she'd never see her money.
I believe the words were, if I've got to sit in jail, I'm not going to pay you back.
You told her that she holds the strings like a puppet, right?
Yes, she does. She did.
Because you wanted her to drop legitimate charges that you had stolen money from her, right?
I believe they weren't legitimate. I believe it was an accident that turned into something because of my history.
You also borrowed thousands of dollars from Miss Spears, right?
I testified that wasn't correct.
Today?
Yes, earlier I just said that.
You didn't borrow thousands of dollars from Miss Spears?
No, I did not.
You told her your name was Kyle Rezick, right?
When I met her in a bar, yes, I did.
Is it okay to give a wrong name because it's in a bar?
Well, I was on probation and I lied because I didn't want anybody knowing who I was. Kenosha's a small city. I say I'm on Aaron Dillard, they call the PO and I get violated and put in prison.
The other problem is if you're trying to date women, they look you up on CCAP and see you're a criminal. That's a problem too, right?
Possibly. I don't know if every woman does it.
But that's one of your concerns, right?
Not at the time. Now it is, now that I'm aware of CCAP.
Well, you were trying to victimize this woman, that's what you said, right?
Yeah.
And when you were trying to victimize her, you didn't want her to find out you were a criminal by looking at CCAP before you had the chance to victimize her, right?
Oh, that's not correct. I told her right away who I was, what my real name was when I started dating her.
Mr. Dillard, the fact is you were taking a shower and she looked in your wallet and then discovered you were Aaron Dillard, right?
That I don't believe at all.
You don't believe?
No, she didn't. I told her who I was. I think I said that earlier.
You told Deborah Spears that you were very wealthy, right?
No.
You drove her to Milwaukee and pointed out a yacht that you said was yours, right?
That's not correct either.
You told her you had a yacht?
No.
Told her you had an expensive condo?
No.
You told her that your wife had been a doctor in Lithuania and that she and your son had been killed.
That's not correct.
You told her that you had a lucrative telecommunications business in Lithuania, didn't you?
That's correct.
And you told her that your assets were frozen in that company, right?
Actually, I sold that company at that time.
You told her that your assets were frozen in that company, true?
That's not correct.
You told her it was a lucrative company?
It made money.
And you told her that you couldn't get access to your money, right?
That's not correct.
You did that, you told her that assets were frozen and that's why you needed to borrow money from her even though you were supposedly a wealthy man, true?
And that obviously is not correct.
You don't believe Deborah Spears was emotionally harmed by your actions?
If she's still emotionally about the $500 that I supposedly took from her, which was never taken, then I don't know what else to say.
What about the thousands of dollars you borrowed from
I
her?
believe I testified I didn't borrow any money.
Are you aware of Deborah Spears having filed bankruptcy as a result of your actions?
I have no contact with her as far as conditions of my probation.
Now, how many women did you meet over the internet that you later borrowed money from or did business with?
Three.
Who are those three?
I think it was Wendy Inu, or no, sorry, maybe 2. Wendy and Shannon Panko.
Well, Deborah Spears you met in a bar. What about
right.
Cassandra Ivy?
No, I met her on a job site.
Lori Brown?
I met her on, Lori Brown. That was the third one.
And you'd post your personal on Yahoo or some other sites too?
At that time, yeah.
Pardon me?
At that time, I did.
And you lied in those personals, right?
Explain that.
You lied about yourself, right?
No, I don't believe so.
All right. You didn't say, for example, that your education was postgraduate.
I don't know if I never clicked the link that said anything about that.
So you think if your personal says that that's just the site's problem? It's not something you would have
Well, I could have, but I don't recall it. It's just a profile. It takes 3 minutes to fill it out. You just click buttons and it's up. If it popped up that way, I never really reviewed it.
So Wendy, is it Wendy Reamer?
It could be.
You met her on the internet?
Yes.
Told her your name was Kyle Rezick?
I don't recall. I could have.
You frequently use that alias to conceal your identity?
Twice I did. If I used it with Wendy.
You told her you played college football?
No.
You told her you were dying of a rare bone disease, right?
No. No.
You told her that you were flying to Europe for special treatment?
Never.
Told her that you had a business in Lithuania?
Yes.
Told her you had a mansion in Kenosha?
No.
That you bought your parents a home next door to the mansion?
That's not true. She picked me up at my parents' house.
In fact, your mom is the one who told her who you really were, right?
No.
You claim to be a medical and surgical equipment seller,
Yes.
and you'd done research to be able to make that claim?
Yes.
You claim to work for the CIA, the FBI?
Never.
And Shannon Pankow, you told her you were Kyle Rezick, right?
That I don't know if I did or not. I met her at the same time as the other ones, so.
As you've told so many people you're Kyle Rezick, you can't remember who you told
No,
to?
I thought it was only 2.
You told her you were a special agent of the Lithuanian government?
I did not.
You told
I was.
her.
Oh, go ahead. Sorry.
You told her that you couldn't fly to Las Vegas because of your position in the Lithuanian government?
No.
You told her you had military clearance?
No.
You borrowed money from Ms. Pankow, right?
Yes.
And you told her you needed to borrow money because you had lots of money, but it was tied up in your retirement, correct?
Not correct.
And you paid her back from your wife's grandmother's retirement plan, right?
That's not correct.
You told her that you were hung from chains and tortured in Lithuania?
Never. Never.
You told her that your son was carjacked and killed in Lithuania?
Not correct.
And you told her kids that you'd be taking them for helicopter rides, right?
Actually, we did. We were discussing going for helicopter rides.
In your helicopter?
No, we were in Vegas together, and we went to one of those places where you could go for helicopter rides. I mean, that's what we did.
And so if Shannon Pankow says those things, other than the helicopter rides, for instance, that you told her that your son was killed in Lithuania, that would be a lie?
Yes.
If Deborah Spears said that you indicated your wife and son were killed in Lithuania, that would be a lie?
Yes.
Did you tell her your wife was killed in Lithuania?
No.
At any rate, you had 17 separate violations
Sounds about right.
right?
Yes.
Sir, defendants exhibit 135. That's a violation revocation summary from Department of Corrections of Wisconsin, probation and parole. Correct?
Correct.
And that's something that your agent came to you with on or about June 21st, 2007?
No, that's not correct.
When did she give you this document?
I believe I received this document, yes.
You just don't think it was June 21st?
I'm pretty positive it wasn't June 21st.
At some point, your agent came to you and told you what the revocation time would be, right?
Yes, what she was recommending. They can't set the time, but they can make a recommendation.
Right, and you refused to sign it, right?
Yes.
And you said, this is a joke?
I said that because there's a 2005 case on there that I was being revoked on. It was a misdemeanor, and I felt that I did that time. I served that extended supervision, and I told them to take it back and bring it without that case number on there.
So you said, your response was, this is a joke?
Yes.
I move defendants exhibit 135.
No objection. Proceed.
Mr. Dillard, you were revoked on 3 cases, is that right?
No, I was revoked on 2, but somehow a third one got thrown in there. I signed revocation papers for an 01 case and an 00 case, never an 05 case, so I never had a hearing, and I never signed a waiver on an 05 case.
All right. So you're saying it was only on 00 CF 1181 and 02 CF 1286, right?
That is correct.
All right. And on the 1181, her recommendation was 2 years, 11 months, and 21 days?
Yes.
And on 02 CF 1286, you're looking at 4 years, 6 months?
Excuse me?
4 years, 6 months?
The recommendation, I signed my waiver was for 3 years, recommendation.
Her initial recommendation was 4 years, 6 months? Is that right?
That was not her initial recommendation. Her initial recommendation when I signed my revocation waiver was for 2 years, 11 months on the 81 case, and on the 86 case, 3 years recommendation.
Is this what you were indicating that she raised it to? 4 years, 6 months?
She raised it to 4 years when I got into the court. I saw the revocation packet that she turned into the judge, or to the courts, and then it was on there as that.
And sir, the second to last page, that's the recommendation in this document is 4 years, 6 months, correct?
In that page, yes, it is.
And that was her recommendation for the court?
Yes, it was. Yes.
And then you were facing 6 years on the new Racine case?
Yes.
That'd be an 07 Racine, right? 6 years. Actually, it's 7 years, isn't it? Because there's 2 counts.
Yeah, there's a 9-month in there, I think. I believe the home improvement fraud counts 9 months. Or whichever one, yeah, home improvement fraud, they're in 9 months.
Home improvement, 1 year?
Is it 1 year or 9 months? I don't know the statute, so I don't know what it carries.
It just refreshes recollection. I'll just show you the criminal complaint. Does that refresh your recollection as to how long it is?
Well, I got a consumer that says that. Yes, 1 year.
So an extra 1 year, and then Waukesha, that's 9 months, right?
Sure.
For obstructing,
Yes.
or lying to the officer?
Correct.
All right. So you're facing, on the revocations, the recommendation from your agent was about 7 years and 5 months, right?
That's incorrect.
Is that not the recommendation?
If you're doing the math and running it consecutive, it is. But I was only facing 4 years, 6 months, because it's run concurrent.
Well, she could, the judge had the authority to make them consecutive, right?
I don't know if I was revocated. I don't know what the statute says exactly, but my belief is that if you revocated once and they ran everything concurrent, that the next one runs concurrent too. They can't remake it and put it consecutive, can they?
Well, if you're being sentenced, you were going back to court for sentencing, right?
Correct.
And the judge had the freedom to sentence you to whatever was appropriate, right?
Yes.
And whoever sentenced you second could say, this is consecutive to the first sentence, right?
I don't know if that's by law they can do that, because DOC would run my sentence regardless consecutive, or concurrent, excuse me.
You're facing at least the 4 years, 6 months?
Yes.
Plus 7 years in Racine,
Yes.
plus 9 months in Waukesha?
Correct.
And the recommendation you're getting is time served, right?
No.
That's the recommendation from the district attorney's office, right?
You're making a mistake. Waukesha, I'm still facing 9 months.
And those proceedings have been postponed until after this trial as well, right?
Yeah, but for reasons that I haven't been able to retain an attorney yet.
The last time you appeared off the record, you talked to the district attorney and told her about your testimony in the Mark Jensen case.
I said I needed time, I told her.
Right, because of the Mark Jensen case.
Yes.
Right? And she agreed to allow you to postpone it so you could come in and try to get credit for this case, correct?
No, that's absolutely not correct.
You're facing over 10 years' time, and what you're getting is a time served, right?
No.
You're not facing... I'm just even going by what you're willing to acknowledge, sir. 4 years, 6 months, plus 7 years. What's that?
That is 10 years or 11 years, 6 months.
Right. Over 10 years, right?
That is correct if you want, yes.
And you recognize that a judge will take into consideration what your agent has to say, right?
Of course.
That agent's been monitoring you, right?
Of course.
And you've been sentenced a number of times, correct?
Of course.
You know that the judge considers your character, right?
Of course.
Considers how serious the offense is. Mm-hmm. Yes?
Yes.
Considers how well you've done if you've been out on probation or parole before, right?
Correct.
He considers whether there's a danger to the community, right?
Correct.
And the recommendation of the probation agent, right?
What do you mean by that? And what is that question?
Your agent's recommendation for time, and also what that agent has to say about who you are, right?
I still don't understand what you're saying. I mean, you're making a statement to me, but you're not making a question, I don't think. What is the question?
You know this kind of report goes to the judge, right?
Yes, of course.
And the probation officer provides information to the judge about you, right?
Correct.
And the judge considers that information,
Correct.
right? Give you Defendant's Exhibit 135. And what the probation officer had to say about you to the judge is, I'm going at the bottom of that page, it's not numbered, it's 4 from the back. And the heading is offender is in need of correctional treatment, which can be most effectively be provided if he is confined. You see that?
Yes, I do.
It says, it is obvious that Mr. Dillard is in need of serious CGIP. What's that? You know?
It's cognitive thinking.
Serious cognitive thinking, but his criminal behavior is well beyond the need of cognitive thinking. His repetitive, deviant thinking is just in plain need of confinement. Even though prisons are normally used for rehabilitative purposes, Mr. Dillard is in desperate need of incarceration. According to the department's client management classification casework control method, incarceration should serve as behavior control and not in terms of punishment. It is at the suggestion of this document that persons with criminal behavior of this caliber show no guilt or remorse. Their goal in life is to be a successful criminal. They are motivated by the power they feel to manipulate others, sometimes for material gain. Per the limit-setting classification, a person becomes excited when running games on others. With this having been said, it is obvious that Mr. Dillard fits these characteristics. Given these facts, it is believed that Mr. Dillard will just view incarceration as paying the price for, quote, doing business, close quote, as cited in the casework control classification. Despite the grim assumption, Mr. Dillard's scamming schemes are a drain on society, and in a perfect world, it would be nice if Mr. Dillard were incarcerated until he repaid all of his debts, which interestingly was the initial purpose of jail back in the 18th century. That's what your probation officer had to say about you, right?
Yeah.
And that's why she thought you should get the maximum time available for confinement.
I believe somewhere there was a typo, but the 3 years I believe they recommended. They recommended 3 years. I think that was 4.6 was a typo somewhere. I've got
That document in front of you says 4 years, 6 months, right?
Yes, but I believe it's a typo. I got the handwritten one that says 3 years.
And then the other 7 on Racine, right?
What about the other 7 on Racine?
That's what you're potentially facing there, right?
Potentially.
And you know that that judge can consider what kind of person you are, right?
Yes, of course.
You testified on direct that your probation previously had been revoked, correct?
Correct.
And you said that that was because you had done a construction job that you should not have done, right?
Correct. Well, plus other violations.
That's not what you testified to on direct, is it, sir?
I believe it is.
Counsel's arguing with the witness, and the witness's testimony on direct was done right in front of the jury. They've got a better recollection apparently than Mr. Albee does, hopefully.
I object to that speaking objection.
If the testimony was not that way on direct examination, then the witness can so state the objections overruled.
Show you what's been marked as Defendant's Exhibit 136.
Would you like this one back? Sure. Thank you.
And that's the decision of the administrative law judge revoking your probation, correct?
That is correct.
And you were revoked on 15 separate grounds, correct?
Correct.
You were revoked for being in an establishment that sells alcohol.
Objection, Your Honor, this has already gone into the witnesses.
You're allowed to question him about specific instances of conduct, not about what somebody else said or did.
Fair enough. You're aware that a judge sentencing you could also take into consideration the viewpoints of an administrative law judge, correct?
Correct.
You had a hearing in that case at which you testified, correct?
That is correct.
Objection, a hearing in what case? What hearing?
An administrative revocation.
You had a probation revocation hearing before an administrative law judge, right?
Correct.
And you testified in that case, correct?
Yes. No, I didn't. I don't believe I did. No, yes, I did. Yes, I did testify in that case.
And you lied in that testimony, right?
I don't believe I lied in that testimony, no.
You understand that a judge could consider what the administrative law judge had to say, correct?
I've already answered that, yes.
And if you could go to page 3, halfway down the page. And the administrative law judge found the following.
Objection, Your Honor.
His name.
Mr. Dillard, do you know who the first American citizen to be extradited to Lithuania was?
Of course.
That was you, right?
Yes.
And in Lithuania, you were committing fraud against Lithuanian citizens, correct?
That is correct.
For example, you obtained $2,500 from a Kostas Algirdis Kurlis,
I believe so.
and that was for his daughter to get a 10-year visa to the United States, right?
That is correct.
And you made friends with them, right?
Correct.
You met them in a cafe, correct? You were very polite and serious, right?
Correct.
You told them that your parents lived in Chicago and that they were very wealthy.
I told them that they lived in Wisconsin. I've always claimed that I live from Wisconsin.
So you deny telling them that they lived in Chicago?
Correct.
Did you tell them that your parents were very wealthy?
My parents had a little bit of money.
Did you tell
The
them?
question.
No, I never told them they were very wealthy.
Did you say they were wealthy?
According to, in their standard, they probably were rich. So I guess yes.
That wasn't the question.
No, I never said they were wealthy. I never come out and said they were wealthy.
And you said you had helped Lithuanians receive USA visas, right?
That's correct.
You convinced them that you were very reliable, right?
Correct.
And you got the $2,500.
Correct.
They were very excited about their daughter going to the United States.
Correct.
You had no intention of producing a visa.
The intentions were in the beginning real, but then everything fell through, and then I just took the money. Well, as long as with the other ones.
You just kept on taking the money and taking the money, right?
Yes.
Even though you were producing no visas.
Yes, I did.
And Mr. Kurlis's son was a doctor, right?
Yes.
And you stayed at these people's house, right?
Because it's, yes, I did at one night.
They invited you over to dinner and you stayed at their house.
Yes.
Right? You were their friend.
Yes.
And then you got the $2,500 and didn't produce the visa.
Correct.
Right? And their son, you told him that you had a BMW distribution deal, right?
I think you're mistaken.
Did you tell somebody you had a BMW distribution deal?
Never.
Did you obtain money from his son?
To buy a BMW, yes, we did. We bought a BMW together.
Do you deny that you offered the doctor's son a profitable business to buy new cars in Europe and export them to the United States where your brother would sell them and money would be transferred to your account?
I think the wording you're using is misrepresented. I think it was more, we'll buy a car together and we'll sell it and split the profit.
And you obtained money from him as well, right?
And I bought the car and sold it.
And you never gave him any money.
There was no profit. The car started on fire.
Well, you took his money and you didn't give him back any money, right?
Hold on, my understanding how business works is if there's no profit to be split, you don't get any.
Or if you borrow money and you don't have it to pay back, that's just tough luck for the person who lent it.
That was me being a bad person.
And the Kurlises you stopped calling them because they wanted their visa or their money back, right?
Correct.
And what you did is you had some woman call them, right?
Not that I recall.
You had some woman call them and identify herself as your maid, right?
No.
You had some woman call and say that you were in the hospital, that you'd been hit by a drunk driver, right?
Actually, I was hit by a drunk driver in
Answer the
Lithuania.
question which was asked.
What was the question asked?
You have that read back.
You had some woman call and say that you were in the hospital, that you'd been hit by a drunk driver, right?
No.
And then you called a week after that, acting as though you could hardly speak, correct?
I don't remember. I could have called them.
To try to sell them some phony story that you were unable to respond to them, right?
No.
You continually promised that you'd produce that visa, right?
Or the money, yes.
You never did, right?
Correct.
You did this on 7 different occasions to 7 different people?
Could have been 7, yes.
Well, that's how many you were charged with. Actually, was it more than that?
No.
And you'd meet these people in cafes often?
Yes.
You'd become their friends?
Not really. Sometimes, sometimes not.
They thought you were their friends, right?
I don't know what they thought.
And you had to do research so you'd be able to sell this phony con to them, right?
Excuse me?
You had to do research to be able to sell this phony con to them, right?
No.
You just knew all about visas sufficiently that you could convince Lithuanian people that you had the authority and power to give them one?
They were looking to buy illegal immigration visas. And I came up with the story I could sell them to them.
And where did you get your information about how to do that?
I can get them and that's it. I don't know any more. How do you research crime? I mean, I'm not familiar with that.
In Fond du Lac, in 2002, you had a woman named Julie Frieda rent a car for you,
Yes.
right? Or truck?
Truck.
And then you took off with that truck and didn't return it?
Correct. I returned it in Vegas.
Well, long after it was supposed to be returned, right?
Correct.
And you lied to her about when you were going to return that truck, true?
Correct.
In 2003, in Racine, you took $8,600 from an Erica Knudsen.
I'm sorry, from where?
From an Erica Knudsen, K-N-U-D-S-E-N, right?
You're mistaken. No, I did not.
Erica Knudsen gave you and your brother Michael Kaiser $8,600, right?
It's not correct.
Did you ever have any dealings with Erica Knudsen, Mr. Dillard?
I never had any dealings with Erica Knudsen.
Did you drop off shingle samples there?
Yes, as a representative of KMM Construction. I didn't. I just dropped off shingle samples and left them on the porch.
So you were dealing with her?
If that's what I didn't talk to her I dealt with her house then because I left them on her front porch. I never talked to her.
And you returned to her house to pick up those shingle samples,
I
right?
left on the same front porch.
And you stated at that time that you would start the contract on June 14th, 2002, right?
Not correct.
And you and your brother received $8,600.
No, you're wrong.
You were charged with that, weren't you?
I was never charged with that.
Mr. Dillard, have you ever run a company called Aaron Construction?
Never.
Are you familiar with the company called Aaron Construction?
Never. Don't know.
You've never heard of it?
Never heard of it.
Now, you promised to begin telling the truth when you started dealing with these prosecutors, right?
Yes.
Thank you.
Mr. Dillard, I'll show you what's been marked as Defendant's Exhibit 137. In count 1, were you charged with theft by contractor for stealing from the Knudsens?
According to this document, it says that I was charged with it. I don't remember that because I've never been convicted of that crime, nor have I. It could have been dismissed and read into another. No, it wasn't even dismissed and read in. It could have been just dismissed because my brother was going through a lot of theft by contractors at the time. And I was involved being his brother and working for him. So as far as that case goes, I have no idea about it. I was never convicted of that crime, nor went to court for that crime.
Now, you were also charged for theft by contractor with Donald Zarowski,
Correct.
right?
That I was. That I took a plea as dismissed and read in to my forgery case that I'm on. I think it was the 02 or 01 case.
So you obtained money from Mr. Zarowski and then did absolutely no work on his house, right?
No, that is wrong. That's where I brought the compressor to do the job on that I caught the forgery for. Because my brother went to jail for taking the initial deposit, and then I had to try to fix it and do the job. He gave me $3,000. I bought the shingles, and then I couldn't afford to pay the labor and the compressor. I bounced a check for the compressor, and then never finished the job.
You bounced a check for the compressor?
I forged a check for the compressor. Excuse me, my mistake on the
You
terminology.
created a whole new check for an entity that didn't exist, right?
Correct.
And you didn't identify yourself as Aaron Dillard, right?
No, I don't know what I wrote on the check. As far as to Zarowski, I did.
You created an entire fake name and printed up fake checks, right?
Yes, that's
And then you
correct.
went and got this compressor, right?
That is correct.
And with Mr. Zarowski, you tore off a portion of his roof, delivered a couple of bundles of shingles, and then you disappeared from their job site and was never heard from again.
That's correct. That's incorrect.
So if Mr. Zarowski said that, he's a liar.
I would ask him actually what he says. Sorry.
Objection, because counsel's expecting this.
And you haven't had prior dealings with Aaron Construction.
No, none that I know of.
You don't even know who they are.
Aaron Construction?
Yeah. Okay. I'll show you what's been marked as Defendant's Exhibit 138.
Would you provide it to us?
Transcript of these.
You had a recorded interview with these prosecutors, right?
That is correct.
The one where you said you'd start telling the truth, right?
That's correct.
And they wanted to know what you planned to do when you got out of jail with this good deal you were getting, right?
They asked me what I plan to do.
Right? And Mr. Jamboy said, so when you get out, your wife will be able to support you until you find a job, right?
That's correct.
And you said, yes.
Objection, Your Honor. This is hearsay unless there's some prior inconsistent statement. If he wants to ask,
There is.
has this witness been asked on this witness
Let me ask
stand?
I've already done that, actually.
may I ask again?
Mr. Jamboy says, so when you get out, she'll be able to support you, meaning your wife, until you find a job. And you, Mr. Dillard, said, yes, of course. And I have actually jobs lined up with Aaron Construction or with Sundance Vacations.
Oh, I could have meant AT Construction. I'm sorry if I made a mistake. It's the whole situation with that. You had a lot going through your mind. I said my own name possibly, but I don't know of I worked for an AT Construction before, and I was planning on applying with them again. So I'm sorry if I made a mistake on saying the wrong word. It was just a linguistic.
That was just a wrong word.
I said probably my name, just being this situation is very stressful. So sometimes your mind gets a little faster.
I see.
And if I had time to think about that question, I probably would have answered it AT Construction instead of Aaron Construction.
Who is, and so it was just that one slip of the...
I believe so, yes.
Okay. Who's Sundance Vacations?
Sundance is a company my wife used to work for.
And then a few lines later, Mr. Dillard,
Yes.
Mr. Jamboy says, what about the construction job, after you talk about Sundance Vacations for a while? And he says, what about the construction job?
Yeah.
And you say, Aaron Construction is a concrete company. They do a lot of brick work,
Yeah.
mortar work, and I'm a mason. So anytime I want a job, he told me I could feel free to call.
Well, that's real. I mean, if it's AT Construction, that's what the construction company was, the brick company. I made the mistake and I kept saying Aaron, probably just associated. I'm sorry I made a mistake in the wording of the word I used. Sorry. I don't know what to say. It's AT Construction.
Do you have a job with them right now?
No, I don't. It's kind of hard to get a job right now.
I have actually jobs lined up with Aaron Construction or with Sundance Vacations.
Okay.
You didn't have a job lined up?
I had a job lined up with, I'm not allowed to do construction work as
No.
conditions of my rules,
Answer
so
the
no.
question. Did you have a job lined up?
I had a job lined up.
And twice is Aaron Construction an entity that you don't know?
I don't know of
Just-
Aaron Construction.
And you also committed theft by contractor against Timothy Franklin, right?
Incorrect.
Timothy Franklin paid $10,000 to your brother,
Of course.
right?
Yes, he did.
And you came to his house to show him samples of siding, right?
Yes.
And no work was done on that house, right?
None that I know of.
And you never returned Mr. Franklin's money?
I had no responsibility to return anything to Mr. Franklin. I was not the contractor doing the job. I worked for the contracting company that did the job.
Let's take a recess, usual, and don't talk about the case during the break. Okay. And the only thing I'd say, I don't think it's appropriate to ask him about what somebody else says. You're allowed to ask him about his own acts and his own words and deeds.
Again, I would generally agree with the court on that, although when Mr. Jamboys took the strategic move of, tactical move of opening all these up, and he's saying, you know, this was just a little forgery, this was just a little that.
I don't recall saying anything like that.
Well, anyway, I'm not going to take any action. I am encouraging you to adhere, both sides to adhere as nearly as possible to the literal rule. I will say sometimes it is difficult to actually ask the questions without sometimes incorporating the statements of others, but all right. Let's start at 5 minutes, no later than 5 minutes to, and as early as 10 minutes to.
Yeah, give me back, please.
So we're taking a break of a minimum of 11 minutes and a maximum of 16.